welcome. My name is Thomas. If you forget it, I've just stuck it up there. I'm from a company, Legalese, all little handles on our website and things like that. We're based out of Cape Town, out of Johannesburg. I'm here in 44 Stanley, but I'm also hopefully starting a partnership with Page and AlphaCode, so you might see me running around here a lot more. The other good thing is of course, we are very much matched to our clientele. So the great thing is physical location is not really required anymore. If you want to get hold of us and you're based out of Nelspruit or you're based out of Daar, that's great. Give me a WhatsApp video call, we'll take it from there. Okay, so who we are, just as a basic kind of description, who we are as a company, Legalese. We are a legal advisory company. We're not a law firm, which gives us a lot more flexibility. So we're a service provider like KPMG Legal, Deloitte Legal, things like that. Okay. The only things we generally can't do, because we don't want to be called a law firm, is we can't sue. So if you're deciding to go to court, unfortunately that's as far as we'll take you. We'll help you all along the way, but then we'll hand you over to counsel from there. But what we specialize in, and what makes us a bit different, is the fact that we have our 6 or 7 kind of permanent attorneys that all specialize in very particular things, but we all work together to make sure that it's almost a one-stop shop for you guys. So what's great is you come to us with a website or an app, we can look at everything. The commercial considerations, setting up your company, all those sorts of things, your shareholders agreements, through your IP, all the way through your regulation and compliance side as well, which is stuff I focus on. So I threw around my business card, you'll see on some of the chairs, but please feel free, grab one off me later, come speak to me afterwards. I'll be milling around, love to come chat to some of you guys. And on top of that, I sent out a few questions through Page to you guys if there was any specific questions that you guys wanted answered or particular focus, and thank you very much for your feedback. I think that a lot of those questions will be answered in the presentation, but then please bring them to my attention afterwards as well. We're going to have a nice big Q&A session, and we'll take it from there. The other thing is also, and what we're focusing on today, is intellectual property. Okay? So I noticed that some of the questions were specifically starting to shift slightly to the right regarding more of compliance and regulation, but that's absolutely fine. This will be mainly IP focused. It might touch on some of those things, but otherwise, please speak to me. We can always help on those other things later as well. And then lastly, what also makes us, I think, a bit different from all the other legal advisories is we do fixed fee arrangements. No more of that hour billable stuff where at the end of the month you get a big fat padded bill. The billable hour is dead. Even ENS will tell you that, okay? Even though they still use it. But what we do is we have invoiced and packaged prices, which is great, so you know what you're getting way before it actually starts to happen. So, excellent. Come speak to me afterwards. We'd love to get involved. Okay, so what we're going to be discussing today, I'm going to jump back a bit in a second, just to share that information. Hopefully I get this right. Okay. You might have come across some of these scenarios. And what we're going to do is we're going to speak about quite a few of contingents that are going to happen that you guys will experience. But I think I just put out a few little examples here of scenes that you have that are related to IP, and I think specifically for a lot of smaller businesses. So what I've put here is the sneaky audience, figure 1. The sneaky audience are the group of people that when you go into a meeting or when you go into a pitch session or something, they're very nice to you, it's all very great, but they have got a serious other agenda in the background. So they might be, oh no, don't worry, this is a very relaxed meeting, we're just here to get a few ideas and to discuss things, when in actual fact, they're writing everything down and they're taking it. Okay? That guy, we've heard some shocking horror stories recently about some guys, even interns, they go there, they pitch their lives out, you know, thinking that, oh no, this is still my idea. No. They had an audience who knew what they were going to do. They take the idea, and a year later, you suddenly see your idea somewhere else. Okay? So that's definitely a scenario that happens often. Another one is the gentleman's agreement. I love this, the kind of ace up the sleeve. I was trying to figure out what card that was, because I seem to recognize that, but you have this a lot. A lot of people enter commercial arrangements or dealings where they simply rely on the word, you know, of the gentleman that you spoke to, the lady that you spoke to. That's it. Ah, we've got a gentleman's agreement. We're fine. No, you're not. Unfortunately, in the world of law, good fences make good neighbors, because of the situation that when something goes wrong, people are never going to want to compromise or negotiate. It makes sense, right? You've got, you know, it's hit the fan for you. You're not going to now start giving pieces away. So what we always say is a gentleman's agreement is not going to work. You need to have a written foundation as the basis of all of your arrangements, even something small and simple. And what we always say is negotiate when times are good, not when times are bad. Do it when times are good, because then people are willing to do things, they're much more clear. Okay? Another scenario is the dawn raid. I always laugh. It took me forever to try to find a picture of the South African Police Services taking computers out of somewhere. It's not a common occurrence. Generally because it's not the SAPS who do it. Okay? What you'll find is that a very specific regulator will come along and they have authority under an act. What they do is they kick your doors in at 4 in the morning and they remove all the evidence they need. All your servers, all your computers, all your laptops, everything. Okay? If you're not ready for that and you don't have a process in place, because there are rights in the situation, if you don't know what your rights are, they will literally take all your stuff and about a year or two later you might get it back. And you don't know what's happened. Did they mirror it? Did they pull literally hard drives out? What did they do? There's a process to follow. Chances are they didn't follow it, the cops. So you want to prevent that sort of situation. And another one is your blatant IP thief. Okay? The guys are coming onto your websites, they're coming onto your platforms, and they're literally pulling everything off it. So either simple, literally your layout, they're going to Control-V, Control-C, use snipping tool, that sort of thing, or they're going for something bigger. They're looking for the software, underlying software, they're looking for an API code, something. Okay? And they're going to try to steal it. So hopefully by the end of the talk, you'll have a much better understanding of how to deal with these sorts of scenarios, and a lot more. So another thing is, sorry, if I talk too quickly, slow me down. Okay? It's a little tendency I have. I get very excited about the work that I do. So what I'm going to do is I just want to talk quite simply about the real axioms of intellectual property in South Africa, understand what it is basically. I don't want to get too deep into it, but we'll discuss the major types. So what I want to start off with is this idea that of intellectual property being an intangible right. Okay? It is rights that you accumulate over these ideas, these concepts, which have been manifested. And that's something very important. You can never get intellectual property rights over something that hasn't actually been created, which is very important. Okay? You cannot copyright, trademark, patent an idea. It must be manifested in real life. Once it's been manifested, then suddenly an intellectual property right can be placed over an object. Okay, so that's something important to remember. It happens often. You go, oh, but that was my idea. Yeah, but you didn't manifest it first, and you didn't get the rights over it first. I think that was the story of Alexander Graham Bell about the telephone. I could be mistaken, but someone else got the invention before him, but he got the patent in first. So unfortunately, history remembers them. Okay, so another thing is important to remember, and a lot of people forget this, it's an asset of your company or a component of your company. So you will get intellectual property rights over something your company produces or is an asset. And what's funny is that the intellectual property right itself becomes an asset of your company. People forget that you can trade intellectual property rights. And you put it on your company valuations. So when you're selling to another company, someone wants to get a valuation of your company, make sure you include all your intellectual property rights. Someone asked about that. How do you find out what the value is about it?
How do you value?
Actuarial scientists. What will happen is there are companies that do this specifically. I'll find a referral for you specifically. We have a gentleman that we use for this. They will literally sit and look at your IP right, and they can value it. So they look at your market influence, things like that. What sort of rights have you got over it? Does anyone else, have you assigned the right to anyone else? Those sorts of things. Okay, so remember, it's an asset at the end of the day, and it protects certain rights of objects or components of your company. So, very famous ones, as you might know, the MGM lion. You know, he makes the big row before he roars before the movie starts. The Coca-Cola font. Woolworths labels, they're very particular about their shelving and their labels and the designs of all that stuff. Even though being in regulations, I can tell you they break the law all the time, Woolworths. You're supposed to put your price on every single item, or you have to have your price near the item. They don't do that on purpose. Okay, because they know that when you get to the till, you'll pay it anyways. Sneaky. And this one is, of course, very important. I've seen this now in Cape Town. It's huge. It's a money-making monster, is a waterless toilet valve. So you don't use water anymore in toilets. And I've seen this implemented in a lot of places around Cape Town. So all of these are ideas in some way that got intellectual property rights placed over them. So if we look at the actual regimes in South Africa, we have 5 main types. And I'm actually quite proud of the fact that we have our 5th one, which is traditional knowledge. You probably won't get that in a lot of other countries. There's, as far as I understand, Africa has quite a few. South America, some countries recognize traditional knowledge. And very quickly, we'll get to the others. We'll focus on the others. But traditional knowledge is effectively any knowledge that comes from a traditional group that you would not have known about had it not been for that traditional group. So I'll give you a practical example. The Hoodia cactus. It was a little cactus that the Khoisan group would use to eat before go hunting. And what that allows it to do is it suppresses the appetite and gives you energy for a long time. So of course, who jumped on that first? The diet and weight loss industry. Because they turn around and said, ooh, this is the perfect thing. Not only does it suppress your appetite, it gives you energy. So they jumped on it, and you're looking at a $1 billion industry. Now, of course, it's unfair for Pfizer to take that Hoodia cactus and make $1 billion from it. They knew nothing about it until the Khoisan told them. So what happens is, under traditional knowledge, it's a bit of a broken system at the moment, but they're trying as hard as they can. You come up with a royalty system with the traditional community. So with the Khoisan, for example, a certain percentage of all income that goes to Pfizer or the CSIR goes to that Khoisan community, and the money gets disseminated. Okay, so that's traditional knowledge. We won't really come across that again, except for the fact that if any of you are dealing in something which you might consider to be a traditional resource, think about that. Okay, you're going to have to plan for that. Someone recently was distributing online games from around South Africa, but they were traditional South African games, learned from the Ndebele community or the Sotho community. That's traditional knowledge. You can't just disseminate that game without some sort of royalty agreement in place. Okay, question?
So you're saying that even if somebody from that community doesn't formally try to create IP and say we own this knowledge, just because they know it, so in conversation, somebody could tell you, oh, do you know that this cactus does this? Pfizer finds out, they do it, and you're saying they can't monetize it without going back and trying to find someone in that community who they can pay.
What they do is that the acts, they've come up with some similar acts. So for example, there's the Biological Resources Act, where they look at the biological traditional knowledge. And they found that exact problem. They said, well, where's the threshold? Is it one guy that knows it, or is it the whole, how do you attribute it to the whole community? That's one of their biggest difficulties at the moment, and they're doing it almost ad hoc. Outside of biological, they still haven't really decided on how they're going to do that. So it is, they're having big problems with the act, because of course also corruption's an issue. The money's going to one person, and then it's not going to, that's it. So there are some issues, but keep in mind that it is something out there. Okay, so what is also very important to remember is that each of these 4 or 5 are distinct regimes that have different requirements. So we'll go through them distinctly, but please do not kind of amalgamate them into one thing. They're very different. Something also to remember, and we'll get to my shocking pictures later. Sorry, I've got a history in school teaching, so I put everything into pictures. Exchange control. Intellectual property is considered capital under South African exchange control legislation. If you try export capital, you need approval from SARB, the South African Reserve Bank. Okay? Intellectual property has been defined as that sort of capital. We'll discuss later there are permutations as to how you can do it without getting there. Well, you always need to notify to some degree, but there are ways of getting around the worst of the regulations. And we'll discuss that. So keep in mind, if you're going to be, let's say someone's designing an app, you've been commissioned to design an app in South Africa and you have to export it back to Germany, you are going to have to go through SARB. Okay? Because it's capital, it is an asset worth a lot of money that's leaving the country. Okay. Yes?
So you said we're going to discuss it later,
yes.
So but yeah, so we're discussing then, you'll be discussing the where does it vest your IP if you design it globally in that type of scenarios?
That we'll definitely get to. That is the hardest question because it's also very much ad hoc, and it's a problem not just in exchange control issues, but in consumer protection especially. Where is the buyer? Where is the seller? Your servers are there, your operators are there, your computers it's all over the place. So we definitely will discuss it. We'll talk about some of those considerations.
So one more question is, so if you commission a company outside of the country to develop an app for you, do you also go through this exchange control?
Interestingly enough, if the app is going to come, if the capital or if it is going to be inflowing, SARB is okay with that, no notification required. So any capital coming in, and this is generally for most things coming into the country regarding asset wealth, mainly around finance and capital, this concept of capital under exchange control, coming in, they don't mind. You are going to have to explain large sums of money that suddenly appear though. That of course is something slightly different. That's when of course you go into your tax regime. So some of our clients, we do a lot of crypto work, we do ICO work, we do crypto exchanges. It's all great until the money in South African Rand hits your account. Then the regulation starts. And they know about it too. So it's all hidden until it hits FNB. Okay. Excellent. And then The other thing is, and this, we talked about this earlier, is that although it's intangible, the right itself becomes a registrable asset. And in some cases, you actually have to have a deed registered for it. And any licenses have to be registered with the registrar. So for example, a design, if you assign a part of your design to someone else, it must actually be registered with the registrar of designs. You have to notify them. Okay, basic. You would have seen also these around. The R, registered. Funny enough, the R actually stands for a few. It could be a registered trademark, a registered design, or a registered patent. Anything that requires registration. TM, of course, is trademark, and patented, you might have seen that, or patent pending, is also a warning because you get some rights, even though your application isn't finalized, you get rights within the pending process. And we'll discuss that. Excellent. Are there any little questions? Yeah, about the basics, yeah.
May I take a picture of your...
Yes, that's another thing. Please take photos, and you are not going to infringe my IP. I give you a non-exclusive, single-use right. The other thing is that what we're also going to do is we're going to make this available on the website from you guys, and we also have a recording that's going to accompany it for explanation. Yes?
If you don't display those, what do you call those?
The marks, yes.
Yeah. So does that mean that you don't have that?
Not necessarily. What will happen is, and this is a very good point actually, thank you for bringing this up now. What IP protection does is it prevents 99.9% of fights. Because someone looks at it and goes, oh, he's got a TM stamp, I'm not getting involved. You are going to have that 0.1% guy. He doesn't care about this. He's still going to do it. Why do these help? Okay, so the short answer to your question is no, you don't have to have these. You still have rights regardless of you proving them every time you put it there. Your rights exist. But why does it help to have these is that when that 0.1% arrives in court, this is an added piece of information to say he knew. He knew. On everything we send out, on every piece of metal we stamp on, every good we push out, there is a warning. So in front of a judge or the registrar, he goes, ooh, it's going to be hard for you to get out of that one. Okay, so that's an important thing to remember. Your rights will exist regardless of these, but these markings and warnings and all your disclaimers and IP policies and contracts, we'll discuss all of those tools, are things there to be proof if a dispute breaks out. Okay, that's very important to remember. It will never prevent 100% of issues, but it'll be proof if you need in a dispute. Excellent, so what I wanted to do is look at some of them now individually. Again, these might be good for some photographs, and it's very survey, guys. So I'm leaving out quite a lot of functional bits here, but I want to just get the most important features here. So, and the other thing is I know who I'm talking to, so I'm not going to be discussing kind of copyright for artistic oil paintings. However, if there's an oil painter here that needs it, please raise some questions. Okay, so copyright. Probably the only time that you guys will deal with copyright is computer programs. And it's a bit of a weird one, but copyright is about published things. Published. There must be a visual representation. And that's what copyright protects, is things called eligible works. And there's a list of them. There is published works, print media, paintings, written works, all those sorts of things, but it's a written down. It's a published item. Computer program has actually been specifically included as a work. Now, why is that great for you guys who are dealing in computer programs? Is the fact that you do not have to register copyright, and it's automatic. The moment you create it, it vests in you. Okay? So, a lot of people try to get what they are doing to fall under the definition of a computer program, because that way they don't have to register, they get the protection immediately. And copyright is great. Literally, I love it because it's the simplest to remember what it means. You get a right over things copy. Literally, you get the right over its copy. Someone tries to copy it, manipulate it, anything to do with the object itself, you have a right over it. Some of those rights, for example, you can ask them to cease and desist. Stop doing the copying. Number two, you can actually ask people to deliver up things. You can say, whatever you copied, you need to actually deliver to me. Some of the things you can also request for is destruction. Literally take those 2,500 copies of that book you just printed and destroy them. and send me a picture of the fire. Okay? You can do that. So there are a lot of rights associated with it. You get 50 years protection, which is great. Funny enough, you'll start to see some of the copyright that has been vested for a long time around the world coming up, becoming public domain again. I think the Happy Birthday song just got released into the public domain recently. A few things are slowly coming out because they're hitting that 50 years or a bit past that. Okay? So, copyright, very, very important. Unfortunately, I cannot tell you what fits under the definition of a computer program, which unfortunately sucks hard big for you guys, because does my app fit under it? Does the underlying code fit under it? Issues. Copyright registrar hasn't dealt with this yet, and the courts haven't dealt with this yet. But a lot of academics think that your coding and everything can, in actual fact, fall under that. There's one catch, though. It's literally about the published design as it currently stands in a static form. You can copyright this layout. The moment you change, or the moment you make, let's say you have an app where you can click on a button and this top window over here changes, that needs a separate copyright. Next thing is a separate consideration of copyright. Next one is a separate consideration. So, when someone says, ooh, do I have copyright in my app? And we'll get to this a bit later, is how do these things apply to modern tech? Copyright, for example, will apply to your app layout, your screen layout as the user looks at it, on your website. That landing page, as it statically sits, you have copyright protection over that. The moment that sort of changes, or it's dynamic, you can't have that copyright anymore because it's fluid, it's constantly changing. Okay, so we'll discuss a bit later. If it's a bit confusing, you'll see the distinctions between them. Excellent, so copyright, very importantly, is probably our favorite. It's automatic, and you don't have to register it.
Can I just ask this?
Yes.
I mean, it's not often that we're sitting in our business that we actually are making the stuff. You've either got a developer or you've got a copywriter writing. So where's the line in terms of, because we've commissioned someone to do something, who has the right?
Definitely, that is a huge focus. We're going to get to that in a second. I've even drawn the pictures about it. But we are going to get to it, but very shortly, whoever commissions owns.
You have to have actually paid for it. Is that right?
No. Consideration makes no difference. So if you did it for free, unfortunately, it also vests in the commissioner. Okay? Excellent. I was trying to think about anything like that. Okay. Interesting. Here, so I'll just give you a little example. Sorry, the resolution's really bad, but here is an example of an architectural layout, a design of a city plan. That plan, as it stands, has copyright in it. The moment someone moves that little green block somewhere else, the copyright for this no longer applies to the other one. Can you see? So, it's very particular to static published things. Okay, designs. Now, designs is a bit of a weird one. Yes?
Just before you go over that topic,
Sure.
What about the process, for example, in an app?
Who?
You know, you do something specific in an app.
Very important. Okay, a lot of guys have come to us and say, guys, and I think this is one of your questions, my process, the way that my app works, the user interface of clicking this and then beautifully kind of and organically going to that, you cannot protect a process or a mathematical formula or a scheme. Okay? That is probably the most disastrous thing, unfortunately, for people in your industry, because in a lot of the fact, that is where your asset lies. My app functions so much better than their one because of the process. Unfortunately, that cannot be protected.
In the States, they do that, don't they?
They have tried to extend it. What they're trying to do is they're trying to fit in process into the other definitions. So they'll say it might be a work. Or, and this is what we might get to, there are some people trying to argue in South Africa that it's part of a functional design. It's functional. How my user interacts with my actual app is a functional thing. I click here and it goes to there, as opposed to, you know, the iStore, which goes to here. So unfortunately in South Africa, schemes, processes, and methods, you cannot do intellectual property for, or protection for, but there are tools for protection, which we will discuss later. There are other ways of protecting those. Okay, so keep that in mind, we'll definitely get to those. Yes?
So an algorithm would qualify in the same context then for the South African market, but in the US?
Interestingly enough, algorithms are probably going to, there's a big debate at the moment, that it might fit under functional design, and it might even pop into patents. The American systems and I know the EU systems are trying to push algorithms into patents. because it does seemingly fit into the definition. Okay. So designs, I want you to think about this as the look and the feel of something. Who's got a very good aesthetic design? Where would you, the iStore. Sorry, I keep using them. You walk into the iStore, you know you're in the iStore. Distinctively, you know you're in there, right? They can actually register a design of the layout of their store. It is literally a feature which is necessity. Oh, sorry, that's functional. It's a design applied to any article which appeals solely to the eye. That's it. Who judges it? It's subjective. It's a very weird one to try register as well. Because you have to say, oh no, my thing is different according to what I think and look at. Okay. So a lot of people have it, but it's as easy as it is to maybe register, it's very difficult to enforce, if you can imagine. The easier it is to register, the more difficult it is to enforce. Actually it's a bit of a mix. Let's talk about functional. Functional, same thing, design, the look and the feel, but there's something about it that actually has a function. So a bottle. My favorite is I see now Corona, I think, are extending the necks on their bottles. Why? So that you don't warm up your beer. If you grab it by the neck, it doesn't warm your whole beer up, right? That's a functional design that you can register. There's a function that it serves. Yeah, that's it. Yeah, maybe drinking too slowly. So again, this, however, designs you must register. You have to register. There's a registrar of designs. You fill out information, and what generally accompanies it is line drawings. Simple as that. So you might have to hire an illustrator or get on CAD or something, and you're going to have to actually explain what your function is. Another thing is it has to be, for both functional and aesthetic, it must be new and not commonplace. And this, I think, might answer one of the questions someone gave us. It must be state-of-the-art worldwide. Not in South Africa, worldwide. So if you've developed a piece of hardware where you think that it's a media player box, let's say, where your button maybe is a much simpler design, it has a functional design, much easier to use, it's got a light up feature, people can see it at night, something like that. However, someone's making it in Myanmar, it might not reach this threshold that it's state-of-the-art worldwide. Okay, so it's a difficult one to register, and it takes a long time because people want to do searches. And we're going to talk about cost. When it comes to registration, when you go to Adams at Adams and you come to us and you go to Spur and Fisher, what's going to happen is we're going to give you a price as to what, in theory, it should cost. What happens is that along the way there are many auxiliary costs that can pop up. So let me give you a basic example. With designs, the first thing we'll do is we're going to search on the systems to see if anyone else has a design like yours. That's going to be a few thousand rand. Then we're going to have to make an application for you. That's also going to be a few thousand rand. And then finally, when there's no objections, it sits with the registrar for approximately 18 months in South Africa. At the end of that, and they say, hey, you're good to go, then you finalize. That's 18 months, best case scenario, a year to 18 months. If someone comes along somewhere in between and says, I object, I think your design is similar to my design, that can slow you down another 6 months. It extends your legal fees because now your lawyers have to get involved and they have to put submissions on your behalf. It's a schlep. Okay? But remember, you can do this all yourself. Don't let lawyers tell you that only they can do it. It's a private citizen right. Anyone can register a design, a trademark. The only thing different is a patent. You need a patent attorney. Okay. Registration required and 32 classes. I'm going to mention these classes thing. You're going to see it again. The registrar has taken the world and put it into 32 classes. They say that your design fits into one of these 32, and you must tell us which of these classes you want protection in. So if you want protection in beverage and food containers, like the bottle, we will register your design in class 16 only. You cannot come now and say your bottle design is also in retail advertising, class 30. Can't do that. If you want that one, you need to pay for that one in addition. This is one place where probably sometimes speaking to someone that knows the system might help, because at least they can tell you what class to fit into without you having to guess. These classes are also, by the way, available all for free online. Quickly, aesthetic designs last for 15 years, functional designs last for 10 years, but you can re-register constantly. I am going to get onto how these apply to more modern examples. I just want to give you the basics. Patents. Patents are about function. I want you to think about tools, things that actually provide functionary uses. It's a new invention which involves an inventive step, completely new. It must be applied in trade, industry, or agriculture, so it must have a proven use. You can't just make something up for an imaginary use. You're not got a lightsaber to fight imaginary. You can't do that. Must have a functional use. And this is where the schemes and methods are specifically excluded, where they say you can't protect all these other schemes, methods, business ideas. Registration is required, and patents are your most expensive and laborious because you have to go through a patent attorney. Okay? A patent attorney is someone with an engineering degree on top of their law degree, because they have to sit and draw full schematics and full schematic functioning explanations for every function, description, everything about your plan. People are trying to get the algorithms in here because they say an algorithm, it involves an inventive step. No one did it before. It's doing things that no one could do before. It can be applied in trade and industry. And also it fulfills a functional purpose. It actually has a technical step. An algorithm will take a piece of information and transfer it to another piece of information. So the EU and the US is trying to push algorithms there, but they're having trouble. And it's difficult. So a lot of it is ad hoc.
Can I ask something?
Yes.
With patents, is it correct, if you put something into the public domain, you can't patent it?
Okay, that's a very good point. Across these, what will happen is there's some of them that have it and some of them don't. What it is timing. Timing is very important. Anywhere where you see the word new, so you're going to have inventive here, and you've got originality in new here in designs, and you're going to have it as well, I think, to a degree in trademark. You must prove that your thing is new. But now what happens if you had a prototype and you gave it in a pitch meeting to someone? It's not new anymore. So that would be disastrous, because you need your guys to go out and pitch. So what they do is they say, for new and not commonplace, and for patents, you have 6 months where they say that we're going to start it from the day that you released it, and you've got 6 months to get the application to us from the first time that you made it public. So if you pitched it in January, you've got by July to send those papers in, those applications in. And you get the protection retroactively. Okay. No, it must be new. And that is one of the biggest objections is you try to patent something, someone comes out of the woodwork and says, nah, but you handed this to me at a meeting 3 years ago. Done. No longer new, throw the patent out the window.
Well, guys, try.
Yeah.
You make a go of it and have a business and then realize it's making money and it's patented. You can't.
That's it. Okay. Trademark. Last one out of the 4 big ones is the brand. Now this one, guys, I kind of implore you to look at. It is probably your cheapest out of all of them and the easiest to do. Trademark is literally about distinguishing goods and services from another person. Okay, so Coca-Cola, very distinct, red, white, black, gray. They've got their colors, they've got their font. Do not try call your stuff Coca-Cola. It will not be accepted. Why? Because it creates something called confusingly similar. Someone in the market is going to think and get confused that it might be the same thing, and the trademark registrar is not going to allow it. So what's going to happen is you're going to register. They're going to ask you, which of the 42 classes do you want? So trademark has got 10 more. They say, what do you want? Are you in service industry? Are you in computers? Are you in what? What class do you want registered? And they, exactly like designs, you got your 3 processes. Do your searches to see if anyone out there has something similar. By the way, you can do that yourself. Maybe make a note of that as homework. If you've got a product out now or a label or a brand that you have now, you can do a lot of the searches yourself by Googling and also going to the CIPC website. Let me just write that down, because the CIPC, Companies Intellectual Property Commission, they're in charge of all intellectual property in this country. I think it's org.za. I could be wrong, it could be .co, sorry. Top of my head right now. And you can always phone the registrars. Registrars are great. They're usually very busy, but they do answer their phones eventually. Yeah.
Is it just taking precaution to ask an attorney to do the search? Because if they get it wrong, and you've gone and spent money and you've done stuff,
Yeah.
that you've got some kind of
Absolutely. So what's going to happen is that when they do the class searches, I'll tell you how we do it as Legalese. You can do a very basic search, you can do a medium, or you can do a very in-depth search. A very basic is the sort of literally we go onto the CIPC register, we type in the name, we type in similar versions of it, and the system pops up similar things. But it's not foolproof. The registrar at the end of the day can still say, hey, it's a bit similar in one way. Medium searches, they look a bit deeper. Now we start to use other variations. Sorry. We add an and, we add a this, we add some punctuality, we add punctuation, we add a few things. And a deep search is we look not just in SA, we look in SADC, and we look around the world as well. Okay, so it would certainly make sense in that you might want to invest a bit more now with an intellectual property attorney because they can do the searches more in depth and more comprehensively. But I think as a start, just to get an idea of what your name should be, just do basics. And remember, when you send in your application, the registrar is going to send you back a notice if something is wrong. So very quickly they're going to tell you, they're going to say, no, you can't do Coca-Cola. Come on, guys. You can't do that. Come up with something else. But every time they do that, that's another 3 months. That's another $2,000 with a lawyer. You know what I mean? That sort of thing. So think about that beforehand. Don't choose a name which you think could be very similar and do some searches beforehand. Yes?
I just want to ask, so let's say you register a name within a certain class.
Yes.
Someone else register that same name in a different class. So that, I mean...
Because it's not confusingly similar anymore. You make wheels for a car, TSW. I make coffee in a shop, TSW. What the registrar is going to argue, they'll say it's not confusingly similar. Someone knows in the industry of buying tires or wheels that TSW makes wheels, but they're not worried about coffee. If they're similar, then you're going to have problems. The registrar will say, you cannot register tires under TSW. There's a guy making wheels under TSW. You can't do that.
Yeah, in the same class, but what if it's in different classes?
That might be a distinct class. The registrar will tell you. They'll say, it's in a different class, but it might still be confusingly similar. So it's ad hoc. The registrar will tell you. They'll say, listen, you're selling clothes and you're selling coffee. They're very different. But we still think people in South Africa will associate them.
So, but then it means you don't have to register it in different classes. You can register in one class.
In one, but then you better hope that the registrar is on your side and gives you that very sort of broad understanding. Okay. Otherwise, it makes the most sense to have it in your distinct because then you can blatantly say, you're in service, I'm in service, clear infringement.
It's cheaper to trademark than it is to fight trademark.
Of course.
So if you're like really sure that it's in various classes, do it.
Definitely.
Do it. Spend the $8,000 or whatever it is.
What you cannot do then, this is what the registrar said, is you cannot register across all classes. Some people try to do that. Big companies do that. Big pockets, they say, right, register us in 42 classes. The registrar says, no, man, don't be crazy. You've got one market and one product. You can't do coffee, wheels, all that. Come on.
So then once the CIPC registers it, it means that nobody can take you on.
That's it. What will happen is they can take you on, but you've got the immediate, like I said, 99.9% of cases, you'll be as a deterrent. But when that fight breaks out and you've got the proof in the dispute, your rights are strongest. And what is that proof? That you registered, that you warned people, that you made people even sign a disclaimer when using it, any sort of proof that your rights are stronger.
About trading as?
Trading as is an interesting one. Trading as is completely not prescribed by law at all. No, apologies. You cannot trade as something that is similar to a registered piece of intellectual property. So if you're trading as 123 you registered as 123 ABC Pty, you still cannot trade as Coca-Cola. Do you know what I mean? You can say whatever you want as your trading name as long as it doesn't infringe someone's intellectual property rights. Okay, good point. Thank you. Yep.
What's the difference between a trademark and a word mark?
Okay, word mark is actually, funny enough, it doesn't exist under the South African system. This is how they consider, they put word mark, the Americans love that concept. They put it under trademark. Okay. Interestingly enough, some things are specifically excluded from trademarks, and one of them is origin. You can't, or very common use things. You can't say, what can't you trademark? Money or cheese or, come on. Those things are so in the common public domain that you cannot trademark that. And the registrar will tell you. Okay? Funny enough, slang is always an issue. Because they'll say, oh no, it's a difficult one. You'll get a lot of objections from that. So you've got a hip new website and you call it, I don't know, Sheezy. The registrar is going to say, no, listen, sorry, that's already part of the public domain, possibly. It's a slang word. Okay. So remember, the registrars, once you get your applications in, it is still quite a long process.
But you could register cheese with a mark and a logo.
Yes, that's it. You can, is cheese like this with yellow and an awesome blue swishing background. That's great because it's distinct and it'll show someone a good or a service. But you cannot have in black font cheese. That's a word in English, you know, that sort of thing. Very good point, thank you. Okay. Excellent. So let's look at the modern application now. So it's great that all of those laws, by the way, were designed in the 70s up to the 90s. So you can understand what we're dealing with here. A lot of these outdated laws have to now kind of deal with what we're dealing with now. So designs, and I have to qualify this by saying it's completely untested in the SA courts. So we're still very much up in the open here. Designs, what some people might have been trying to say is that actually underlying software, so now you've got your code that runs your app. Some people are trying to fit that under functional designs and to try register it there because they say that it fits the definition. It's a design of code. I've put this line first and this line second and this line third that has a function. It fulfills a particular purpose, which it does. If this, then that will trigger something in the program. So some people are trying this to try to protect their underlying software on their app. Hasn't been tested yet. And the registrar, I don't think, has been challenged yet. Because it's an expensive process. No one's going to go in there and spend 10 grand on a test. Okay? Might happen though. Copyright. This is, I think, very important for the guys. It's a bit of a tough one. How do you use it for your apps? Literally your landing page on your app or your website pages, your static pages, you have copyright in those automatically. You see someone had just Control-C, Control-V your page and stuck it somewhere else, you can take them for copyright infringement. Okay? And the other one is it can protect static code. I don't know why you would ever have to do this, but if you had to actually physically print out the underlying code or send someone a screenshot of code, those static representations of the code are copyrighted. Okay, so if you send someone a screen readout of 45 pages of code, you've got copyright in that because it's a static representation. Okay. Patents. Some people are trying, like I said, to put the algorithms in there because they say that it's novel, it's used in trade and industry, it has a technological function, and they're trying to insert it into there. But I can tell you now, the Patent Registrar of South Africa does not know how to deal with that at the moment. And if you think about it, the application trying to describe it is going to be quite a lengthy process, and you're going to have to find a very particular patent attorney that can do that. I reckon there's a handful of them in SA that not only code themselves and know coding backwards, but also lawyers. Yeah.
Just want to return back to your comment around copyright. Static code, I'm thinking of an API.
Okay.
If one publishes an API, which is in a very specific format,
Yes.
that is intended to be consumed by other websites or other users, etc.
Yes.
That API, it sounds like, can be protected because it's static code.
Here's the catch though. If someone comes along and takes that static code and merely changes a few things in it, but it ultimately still performs the exact same function, it's no copyright infringement whatsoever. They won't because it's static, it's set.
That field has to be, the endpoints have to be, so it is quite a static piece of thing.
Absolutely.
It doesn't work if you change it.
Very true, but then also remember, why would you want to protect that underlying code is because of the representation it creates, right? I want to protect the code because that code creates the layout, the look, the feel, everything, the functioning of that part of the site. Copyright doesn't extend into that anymore, it's gone. So the moment someone takes that static code and manipulates it a little, not manipulates it, but comes up with another way of writing it to end up with the same result, they will come up with the exact same result as you, but they've just used a different type of underlying code, there's no infringement. That's why copyright doesn't really work. The best thing the copyright helps for on apps and websites is merely the layout. That's it. So copyright, unfortunately, doesn't really help you much on that. Okay, these two are very big, and unfortunately, this is going to scare the pants off you. I don't know if any of you guys have been involved in or heard about the Copyright Amendment Bill I don't know where they got the impetus to suddenly pull their finger out and kind of update all the laws in this country. But I can tell you now, what they've done is, under copyright, if you want to use someone's copyright, you need to pay them for it, right? Give them a royalty, give them something. To who? The creator. What government is trying to do now, so weird, is they're trying to insert the user as another party that's entitled to royalties. So let's think about that practically what it means. It means that I create a video and I post it on YouTube. 100% my intellectual property. Someone comes along and retweets, reshares, resends that video elsewhere. That user who did nothing more than share it is now entitled to royalties. Okay? That's crazy. What that also means is it could mean that distribution points are also entitled. So if you put your app on the iStore is actually entitled to royalties now. People that use your app are entitled to royalties now. It literally makes no sense. If you get online and you type in copyright amendment bill, you are going to see the worst swear words you have ever seen in your life. It's just this dump down. I see where they're coming from. Kind of. They recognizing that in actual fact, a lot of the time, there's a lot of people in a distribution chain that add value. I get that. Do you know what I mean? You can have one guy making a video, but it's the actual chain that's responsible for sending it out. I get that, but at the end of the day, you can't just have a blanket word like user. That means every one of us deserves royalty.
Those negotiated relationships.
It's literally like one of the weirdest. If they put in a if they said other parties that have contractual relationships with that makes sense. This is literally open-ended. They say a user. And they don't define what that is. They just say it's a type of creator. So please keep an eye out for this. It's going to rock a lot of people. Okay? Another thing is the Film and Publication Amendment Bill. Hopefully going to be an act soon. The FPB, I don't know if you guys have seen these logos. One of my favorite things, I worked very closely with Netflix, with Thomson Reuters, all these guys that wanted to bring in video on demand services to South Africa. And what we always warned them about was the FPB, okay, the Film and Publication Board. If you distribute media in South Africa for a commercial reason, you need to classify your content. Okay, that gets a bit weird now. What they wanted to do about 6 months ago is they said, anything that you distribute online, commercial or not, you must classify. So the picture of my family weekend that I post on Facebook, I need to classify with the FPB and pay a fee. Yes, that was the case 6 months ago. People were going crazy. They said that's never going to work. Okay, fine. They learned the lesson. So what did they do is they said, fine, everyone commercially distributing media online. And who did they go for first? Netflix. Did any of you guys see that dispute that broke out about a year ago? The minister went to Netflix when they first launched in South Africa and they said, you guys are distributing commercial media in South Africa. You need to classify every single piece of content you're bringing here. What did Netflix say? They turn around and say, where do we operate? And this goes back to your point now, exactly. Where do you operate? We're not in South Africa. We're cloud-based. We've got our servers out of Manila. We're running some guys out of San Francisco. We're running some of our other servers out of, I don't know, wherever. We're not in South Africa. Prove it. I think we have a secretary sitting in Joburg somewhere in an empty office. That's not a presence in South Africa. So the FPB said, you owe us $1 million. How much was it? It was a few million rand. Netflix said no. That's all they did. They just said no. And that was the end of it. Finished. So what's happening is that this only works if they have leverage over you. And it still is debatable. So DSTV, unfortunately, is starting to toe the line with these guys. But they can do in-house. What I'm warning it for you guys is if any of your systems commercially distribute media and you make money off it and it is a central tenant to your app or your website, you are going to have to speak to them at some point in the future. Okay? And they are not such a fun bunch. Yeah.
When you say commercially distributed and make money off it, I can understand in a Netflix context.
Of course.
If I've got a social media channel and my social media guys find funny GIFs and retweets content and YouTube clips and things like that. It's for social media purposes to drive traction into the site. It's not for...
That's it. As far as the definition, because that was exactly it, is that the FPB are focused on your Netflix. And that's what they repeatedly said to us in these submissions, because that's what we did. So I said to them, I said, what is your definition of commercial distribution? I'm getting clicks on my thing. I get a paycheck of R5 from YouTube at the end of the month, let's say. Or I'm bringing in indirect money to my company because of traction. All they say is, we're not worried about you. That doesn't help me. I'm a lawyer. You know, you need to give me exact triggers. Unfortunately, they're not doing that. Okay, so the best I can tell you is they're looking for the big guys making big money. And unless you are literally charging, let's say, a subscription, you're relying on traction and things like that, they haven't got a problem with you. Okay. So this is in the pipeline, and keep an eye on it.
Does that extend to educational content? So if I've got an e-learning platform?
Yes, but now here's the thing. Education is a bit of a weird one, because there's an exception in most of this intellectual property that says you can break intellectual property rights if it's for a direct educational purpose. So do you remember the old teacher? Some of us had this. Your teacher would sit there and either photocopy pages out of the textbook, you know, and then bring you pages. They're not breaking the law in that case because it's direct educational purposes. But in your case, what they're going to say is they're going to say, nah, you're not part of the public education school system. You are there to derive a profit from your system. You're a money-making enterprise. So that education thing goes out the window. Okay.
Do you then have to register with this FTV? If you make clips and you are charging people to watch it?
That's exactly it. Is what's going to happen is that the threshold of how much money is the trigger to get registered, they've not defined that yet. And that bill is still in process of working now. So they haven't decided, if you're making R1,000 a month, if you're subscribing for R2 a video, they haven't put any of those guidelines in place. We hope they will. So hopefully there'll be a thing saying, if you're making more than R1 million a month, commercial distribution.
What is that, a body that does, what value do they add?
Can I tell you what their sole purpose is? And this is a very frustrating thing for me. It's child pornography they're trying to prevent. Now, I 100% understand their motivation. What they're doing, though, is they're using emotional blackmail to steamroll through functional laws. We all don't want, no one wants child porn to be proliferate on the internet. But what you also don't want is for them to now take every single site in South Africa and make it subject to classification. But unfortunately, that's the case. You go to these meetings and all they talk about is child pornography. It's shocking. Because they emotionally blackmail. And I've seen the minister get affected by this. By the way, the minister at the time didn't know what an app was when they were discussing classification of it. Okay, they had to stop the conference, get the app on her phone, and then show her the PEGI ratings and things like that. So it was a bit of a tough. That's what we're dealing with. Okay, but it's getting better. It's not dire. So this is now harking back to the point that you raised earlier. There are tools, guys, outside, some of them inside, the intellectual property regime that can protect you that are not necessarily registered functions. So you can still get protection even though you don't register something. And I'll bring you examples of those. So, you know what, let's start on talking about that. Let's start on contracts. Most important one I'm going to list here is the NDA, Non-Disclosure Agreement, guys. You must have one of these in your laptop bag. Do not make it more than 2 pages long. No one wants to read it. Get it signed. If it's unsigned, it means nothing. Unless you have a clause in it that says this is a unilateral agreement, your mere acceptance of this document means that you've accepted it. I love that line. I put it into all my contracts. Okay, it's a unilateral acceptance clause. If you don't have that, they have to sign it. Keep one in your bag. You can Google one of these. Don't go to a lawyer. You can go to a lawyer for one. We offer them. Just go get one online. Okay? Very simple. Basically saying 2 things. Number 1, everything I'm telling you is mine. And number 2, all the rights vest in me. And I'm going to come after you if you break those rights. Simple as that. And what that also does is I find not just commercially protects you, but it gives off a very nice assurance to the business that you're pitching to that you know what you're doing. Okay? It shows professionalism. It shows professionalism, yeah.
I've seen quite a few NDAs nowadays that have an expiry on them.
Yes.
That have 1 or 2 years and then it expires.
Absolutely. Where that stems from, I have a suspicion, is from, what do you call it? Restraint of Trade. You know the Restraint of Trade clause? Restraint of Trade clause is effectively you sign it when you're working somewhere, and when you leave, they restrain you from working in the same industry. But what's been coming up in the courts is they say, those are unfair when they start getting very wide. They say, you can't work in South Africa for 25 years. No, that's stupid. And the courts have cut that. And I think there might be a bit of seeping into the NDA too, saying, guys, it's unfair to maybe hold this guy's idea for the next 65 years in all formats. Because in your NDA, you can say that. You can say, I protect not just my idea, but every derivative article coming out of it. Now, of course, that's going to be hard to prove in a fight, but put it in there. Make your protections as wide as possible. Okay, so one of the contracts, very importantly, is an NDA. Number 2 is a licensing agreement. If you are, I'm also going to put licensing, there's content agreement. Remember we were talking about rights, that you own rights. A licensing agreement is you are giving someone a license to use your rights. Simple as that. So you're going to come in and you're going to say to someone, I'm going to produce for you this website. Oh, let's choose another example. I've built this website and you've got a customer from overseas that likes it. You say, no problem. You have the ability and the right to use my underlying software, my layout, all these rights that I own, and here's the license. And it's covered in an agreement. And they take that and they keep it in their office. And if anyone claims infringement or something, they turn around and say, I have a license to do this. Okay? By the way, when you try selling, when you're pitching to companies, they want to try buy your company, things like that, they're going to want to know about who owns your intellectual property, and they might want to see any of your licenses that you have from somewhere else. So if some of you are on white label agreements, maybe with software companies, you're using bits of software from around the world, they are going to want to see copies of them. Always have them on hand. And please don't sign anything that you haven't read. Okay? Those things get quite complex. Be comfortable with everything. Content agreement. Content is, it's a bit of a in-between. Content is literally going to be, it's similar to the licensing. I am giving you a piece of product to use. Not the license maybe to use a bit of this or a bit of that. I'm literally giving you this website. Full, done. So it's very similar to the licensing. And I want to now bring your attention to this. Another shocking picture. This now leads to commissioning and apprenticeships. I think of, internships. There's an automatic assumption in law that if someone commissions you to do something, they pay you to do something, or you're an intern for someone or an apprentice for someone, anything that you produce, all the intellectual property vests in them automatically. But, and this is very important, there's no reason that you can't contract out of that. So, scenario 1. I love this, this is my Monopoly man. This is the man, because you can tell from his top hat and his monocle. Okay? He's paying money to the person with the laptop, the little L. He then hands over his rights, and they send the product to the client, or they send the product back to Mr. Man. Right? So because you're giving me money, I give you rights. All of them. This happens often. You go into a meeting, the guy's giving you 2 million rand in cash in a suitcase. I don't know who actually, that doesn't happen to anyone, but you got your 2 mil, and they say, right, sign here. What they're trying to do is they're using the leverage and they're exploiting the situation and they're getting you to just hand it over. Because the moment you take that money and you don't qualify it, they get everything. And they can do whatever they want with it. Manipulate it, change it, cut it, edit it, whatever they want. Okay? Where did you get smart? You come in and you say, you give me the cash, I give you the rights, but the rights, I'm going to limit them according to what I want. And according to you want. It's going to be a negotiation. So this happens very often. Let me give you an example of published works. Or, no, let's take the layout of a website. Perfect. What will happen is that you say to them in that agreement, I give you the layout of the website, but I keep the moral rights, for example. You are not allowed to manipulate it. You are not allowed to change it. If you want to change it, you need to ask my permission. If you want to add something, you need to ask my permission. You can qualify the rights that you give them. And where are you going to do that? In your commissioning agreement or in your service agreement. Most of you, I'm hoping, have service agreements when you engage with people. Either someone giving you a job or you taking a job. So I'm going to write it over here. Sorry, it's a bit low. is your commissioning or your service agreement. All of our service agreements that we give out as legalese have an IP section. Heading 6, intellectual property. The seller gives the product over to the buyer, subject to the following conditions. I retain all manipulation rights. You may not put this in any other format. You may only operate out of domains in Southern Africa. You can say whatever you want. That's negotiation. So do not feel that because this guy's giving you 2 million rand, you need to give him everything. No. He'll give you the 2 million rand, you can negotiate. He might give you a bit less, obviously, because of the fact that you're retaining some of those rights. But guys, you need to protect yourself. Okay? Especially around brands and things like that. We had a horrible situation where an illustrator painted an oil painting, beautiful oil painting, had 0 intellectual property protection in her service agreement. And then she found her oil painting and being manipulated into a digital image, and some weird violent image had been superimposed onto her original oil painting. But enough that people could still recognize that the underlying one was hers. So she got like phone calls from her mother's church group going, oh my God, how did you release this picture? She said it wasn't me. But she has no rights to control what the commissioner did because she didn't stipulate them. So please understand, it is your right to qualify what you give away. Okay, very importantly, all your service agreements, all your commissioning agreements, please make sure there's an IP clause in there. Excellent, so that's agreement. Ownership rights, we discussed this, that if you are, and this, oh no, that's a slightly different, sorry. So we discussed commissioning internship. If you're commissioning, you've been commissioned to do work or you're working for people, it automatically vests in them. Licensing, we've discussed. Assignment. Assignment is an assignment agreement. We discussed that you're giving people certain rights. Okay? Contracts we've talked about. Ownership rights, these are what can you do if someone now breaks your intellectual property. Okay, so you find out that someone is doing something with your IP. What do? First thing is you send them a letter of demand. Okay, a notification, an LOD as they like to call it, a letter of demand, and you clearly state what your rights are. So you say, I have a design registered. Here's the deed of registration, the certificate of registration. Here's the number. These are the 3 ways that you're infringing it. Stop it now, or I am going to do A, B, and C. And then you see what happens. If they don't, you enforce A, B, and C. Interestingly enough, the first port of call, I'm running out of space here. First port of call is the registrar. That's the first person you report to if there is an infringement. Someone's infringed your IP, you phone the registrar. Second person is court. I can tell you now, I used to do a lot of litigation. South Gauteng High Court, you're looking at approximately 400,000 rand to bring a summary judgment application in the High Court. And you're looking at a waiting period of about a year. It's useless. Don't go to court. It's not going to help you. That is why we need as many things in place as possible to avoid going to court. Okay? Interestingly enough, a lot of people put another option. Now, this is not for enforcement. This is for your service agreements. If you were doing a job for someone, please put an arbitration clause into your service agreements. You don't want to go to court. Arbitration is great. It's binding if you make it binding. You can do it in your own time. You can set the rules. You're an objective party. Yeah.
I've had an example in business that I work with where we got a letter of demand.
Yes.
Firstly, it's from a firm of attorneys saying they act on behalf of the client who has the patent. But I've since had a stream of the same letter coming from the same attorney for all different clients. I suspect that attorney is not actually working for those clients, that they're out on a fishing expedition.
Really?
Is that...
I can tell you this. There's a very upsetting practice that happens. The very big law firms do this. They've got like a secret room around back. What they do is they sit with the register of all intellectual property, designs, trademarks, patents, and they wait for the publications once a month to come from the registrar. And they sit there and they go, that's similar to our clients. and they just pump those letters out. They don't look at them properly. They don't look at what class they're in. They don't look at anything. They generate fear and billing. So number one, they're on retainer. They have to justify the R1 million a month fee to their client. And number two is they just create fear in the market that no one will ever try and even enter another class. Because these guys are going out there and just sending you letters. If you get one of those letters, very easily look through it, very calmly discuss it with them and say, no problem, let's have a meeting with the registrar. Because the registrar at the end of the day doesn't care about lawyers, doesn't care about this guy, that guy, anything. They sit in Pretoria, 20 minutes less. The moment those lawyers hear that, you're going to watch, they have to then establish their rights a lot stronger. You won't get some random, you're infringing my copyright, stop it, with no rights and no anything.
Also, when I looked at it, the particular words they were using was, in a sentence, I had the words one and place in a sentence, and they said that trademark that, the words one and place, and that could not be used in a sentence.
Okay. Best thing to do in that situation is you ask them for their like proof of their rights and their claim. So they'll have to send you the certificate of registration. They might have to get a statement from the registrar. Very quickly go, thank you very much for the proof. I'm setting up a meeting with the registrar next week. Please can you attend? Very quickly that letter will go away.
That would call them out.
Yes.
To that, yeah. Because it really feels like either a billing exercise or a fishing expedition.
Definitely, definitely. Literally, they have. I knew a CA, a Canada attorney. That's all their job was. The company's name was like Fidget, so they sat there and just with a list, just going, Fadget, Fidget, anything. Just kind of send them a letter. It's too similar. Okay. Excellent. And then the last one. A lot of people mentioned this: offshore transfer. Okay. South African Reserve Bank, like we said, they're interested in capital going out. Intellectual property considered capital. Okay. There are two permutations. SARB understands that this is problematic. You need to send examples of, the computer programs and intellectual property overseas. Why? Pitching, things like that. You've got a foreign client, they want to buy your company, and you need to show them an example of how it works, or you need to show them, send them pieces of operating software or something like that. You can't now have to make an SME go through this whole SARB rigmarole. So what SARB did was they said, okay, fine. We come up with a middle ground. There's two general exceptions. You still have to notify SARB, but there's two general exceptions which they allow a lot of flexibility with. Number one, let's do it like this. Can you see my little, sorry about all the radio, can you see that we've got one arrow going to one person, and we've got one arrow going to many people? Okay? This first option is when literally you're selling your product, your intellectual property, to one client, and you're sending it overseas. Example, a German client commissioned you to create a piece of software in South Africa, you send it back overseas. Okay? Only to that one client, nothing remains in South Africa. SARB does not like that. Why? Because if you think about it, practically everything is leaving the country to one person. They don't like that. They say, okay, fine, you can do it, but you need full approval from us, and you need to notify them in a very particular way. The SARB website has all the information. The Res Bank website has information on how to do that, and so does your bank. FNB, Standard Bank, all of them, they've got an exchange control department. It's usually a little side door next, kind of like the exchange, Go speak to them, they'll know what they're doing. Okay? What SARB is much happier about is if you license out the intellectual property. You send over by agreement either the entire product, which they may use, but it's on conditions. And the control and the functioning and the main control of all the intellectual property still remains in South Africa. Okay? You can create, being in control in South Africa, you can create updates for it, you're in charge of the coding, that sort of things. You're in charge. All you're doing is you're allowing someone overseas and multiple parties overseas to use that same bit of software, but it's not theirs. They may use it, it's not theirs. Both of these require notification. This is going to require more requirements. There's going to be more obligations, sorry. And that's going to be less. So.
That's a clear transaction. Like I'm selling you something. What happens if you have an overseas company who wants to use something of yours?
What Saab will regard that as is that is situation, is that asset is still leaving the country, but it's on a license agreement. It's not leaving. Use of it is being used somewhere else.
Okay, but what stops you from setting up a company overseas, building something there, and then let them use that because you know how to?
Okay, very good point. Someone asked this as well. What is the benefit maybe of trying to register the intellectual property overseas as opposed to South Africa? Okay, very, very important. What the functional difference is, it's all down to practicalities. There's nothing stopping you if you think that practically speaking you are going to be doing a lot more business overseas than you are going to be doing it locally. It very much makes sense to go and do the registrations in the jurisdictions in which you are going to be operating the most. Okay? Remember, you don't get cross-jurisdictional protection for intellectual property. There's some exceptions, but if you have a trademark registered in South Africa, it's only effective in South Africa. Okay, there's some conditions to that, but that's the way it should be. All your intellectual property has to be registered in separate jurisdictions. So if you want to register in the UK, that's great because you're doing a lot of business there. But imagine you're registered in the UK and you're doing a lot of business in South Africa. The UK regulator is going to have an issue. They say, hold on a second, are you operating there or here? You might have to give us notification for operating in SA. And setting up registrations in England probably will be a lot more expensive than here. And the processes are more difficult.
But doesn't it mean that you are on an exit, or if you sell your business, it's a lot less attractive to international investors?
That's it. So that's another one of the practical considerations that we have, is some people say, guys, we're doing more business overseas. Our investors are looking for registrations in those foreign markets, in which case, please do it. Go and register overseas there. And do that, because then it's practically worth your time and your money. But you must think about it as a functional thing, guys. The only benefit to registering overseas is you get protection overseas. Unless you have a reason for having that protection overseas, I really wouldn't waste your time and your money doing it, because it is a schlep and it's expensive. And they have their own conditions for trying to enforce foreign law in SA. So think about it, okay? I know a lot of people come to SA because they want to use our cheap software developers, supposedly, in SA. It's not really the case anymore. Because those foreign laws also have their restrictions and their issues. And now, like I said, if you're trying to export it back out of SA, Saab's going to have an issue. Okay.
How are you really exporting?
The way that they see it is, let's say you literally send over a package, I want to use this, I'm going to make a very blatant example.
I'll give you an example. So we have a financial education business.
Yes.
So you set up an office there, you put a team in there, you build product, you start billing someone, they start distributing, and you make money. It's got nothing to do with the South African Revenue Service.
Absolutely. What they're going to say there is they're going to say that asset originally came from somewhere and is being controlled from somewhere. If you have a license agreement in your UK operations, that's fine. That's what Saab likes. They're okay with that. Because they're saying you're still using it, but it's deriving from SA, and we want to make sure. They might have an issue with that, yes. They'll say that where's the money eventually going? Where is maybe derived money? Is it going back to the holding company in SA? They need to know about this relationship. For example, they'll ask you for a copy of the licensing agreement from your UK office. They'll say, where's the agreement between your SA office and your UK office? They'll say, no, you can't do that. Then what you're doing is you're handing over, or you have nothing to do with each other. There's no proof that their software is the same as yours.
Okay. Is it much tighter around software?
Yes.
Not so much around content, because content...
No, it's much more around software. Remember, guys, and I want to make this clear, Saab do not know about most of this. They will never know about most of this. If you transfer your software between your guy sitting on his laptop and the other guy sitting on his laptop overseas, they're never going to know.
Except if they look.
That's it.
If they investigate you,
If they
the money
investigate
has to
you,
have come offshore and it had to have been built on an IP address overseas.
So they'll say, well, where'd you get the $1 million from this year? We've looked at your account for this. And you say, oh no, it's from a licensing arrangement we have from guys using software overseas. I say, excellent. Where's your notification to Saab? Saab, what they do is, and like most regulators, there's a proactive duty on us to adhere to the law. So if you think you're doing something wrong, you have an active duty to go and tell Saab. If they find out that you're doing something wrong and you knew about it, that's when they smack you with very big sanctions. And remember, Saab is in charge of almost everything cross-border. So they will phone SARS, they will phone customs, they will phone everybody. They can even phone your ISP. And they'll say, watch them. We want report backs on all of this. Okay, so they are a very powerful body and you don't really want to mess with them.
I have a question.
Yes.
It doesn't make sense to me. So let's just start at the beginning. So you have an app or
Yeah.
a website that does functional training or whatever.
Yeah.
So firstly, so you can't get the IP on the functionality of the thing.
Not on
But
the functionality.
IP is on the look and feel of the thing.
That's it.
Okay, so now Saab says you're exporting your IP, but the IP
Capital.
is not the system, it's just the screens.
That's
They
it.
just move the screens. Is it 1 centimeter to the left? What is the essential? I'm getting
What is the
confused.
value?
What is Saab saying you can't export because your system and your functionality, which we consider IP, it can't be IP.
Doesn't have capital.
So it's a contradictory.
It is, it absolutely is. Remember, all that Saab is looking for is this concept of capital. If what you have does not fit into that, so a piece of software, literally like an Encarta CD in a box that you send overseas sort of thing, Saab understands that as capital. The moment, and then licensing on bigger programs, use. The moment that that starts happening where like, we don't actually have intellectual property in it, in this program, therefore we don't have capital in this and it can't derive any monetary function. Saab actually have no reason to touch it because it's not considered capital. However, we don't know if they're going to decide if it's capital or not. So what we always say is when these guys have these sorts of arrangements and you think you might be tripping it up, phone Saab. They're guys whose specific job it is to field exactly these questions. And they're going to ask you all the practical stuff. They're going to say, what are you doing? How much money is it? How long has the company been dealing there? What are you dealing exactly with? Explain it to me. Show me an example. And then at the end of the day, they'll go, it's capital.
I always go that way because it suits them.
Sometimes yes, sometimes no. I've heard some you guys have heard about the crypto, the sandbox that they're supposedly everyone is playing in, right? I love this buzzword. Everyone's in a sandbox. Oddly enough, we've been stepping in and out of that sandbox with our clients, and Saab has actually been surprisingly cool about all of this. Not once have they said, don't do it. Their approach, and I can't believe they said this, is first do it, and we'll come back to you if you have any issues. If you think it's problematic, then speak to us.
Those film production things where if you're worth enough money, we'll come back to you.
Oddly enough, but what they're finding, and this is also what I'm finding weird about Saab, Saab only used to listen to these old white guys sitting in big banking buildings. They're not doing that anymore. Okay? They've recognized that the large amount of influence and where this industry is going is coming from us. And they're willing to now listen to us, and they're not putting it on the basics of, oh, this is the law. And tell me about exactly that capital. Phone the raise bank, say, listen, this is the situation. This is how we're looking at it. We don't have any IP rights in this stuff. Do you consider that capital? No. Thank you very much. Please put that in writing and email it to me.
But doesn't it
It's scary though. It is scary.
in terms of how you account for the IP? Because if you expense it,
If you put it on your books, if
put
you
it on your books,
expense
if you
it.
capitalize it because you're trying to one day sell the IP to someone and say it's worth capital, you'll have that issue.
Added proof it's capital. SARS are going to do that. They're going to, maybe that's it. They might request your financials.
It's always expense anything for only when you sell it capitalize it.
Can you see, but maybe-
capitalize something before you sell it. Expense it and then capitalize.
So guys, Saab is a bit of a weird, all these regulators, always a bit flexy, but Saab are really good, and what I'm trying to say is that they're positive and they're friendly and they're nice and open. Okay. Last things, and this is just interesting, these are practical tools. Please remember that you might be involved in PUPI, our favorite friend, Protection of Personal Information Act. If you are an operator, if your website does anything that manipulates or processes information on behalf of someone else, you are liable. And you have obligations and duties. PUPI is big. Please do not wait. You have a 1-year grace period from when it comes in. I'm telling you now, it will take you a year to reverse engineer your app if you do not plan for it now. Okay.
So if someone sends their customers to you, you're now in control of that customer's data.
You are considered an operator or a responsible party. The two things, you both have duties and obligations.
What do you need to do?
Lots of hectic stuff. Speak to me afterwards because there's a lot of stuff that has to be done. Okay? Another one is NDA. We spoke about. Have an IP policy, please, guys. Please, please, please. Have an intellectual property policy on your website, on your app, in physical person. If it's in your agreements, have an IP provision. If you have a website, please have an IP policy. Very simple. It's a hyperlink at the bottom of your page, or it's part of your T's and C's. says the same thing. Everything on my site is mine or is licensed. Do not touch it, do not remove it, and if you do, I'm coming for you. Okay? Very important, very simple. Again, you don't really need a lawyer for this. It depends on your industry, but you can get quite a nice, simple one offline quite easily. And tech tools. You guys could probably absolutely blow me out the water with examples of these things, but there are very interesting techniques I've heard of guys just protecting their stuff. So, put dummy code in your code. Put a watermark, a visible or invisible watermark over maybe a layout. I know that there's some interesting software encryption programs that are now being sold that specifically does this stuff. It encrypts maybe the layout or certain things that be your coding, and then only decrypts on the other side with the person who has the same software to prevent issues. Okay. So think about practical bits and pieces which might help you along the line. And I think that these, if you have these, chances are you'll actually protect yourself the most and the best. And that's it, guys. So, I'm going to be milling around here. I'm kind of cruising around. Speak to me if you have any issues. Otherwise, I've thrown some cards around. If you want from me, please come get it. Everything you've seen today, we do. And we cover the entire spectrum of sort of services, from commercial, secretarial, to IP, to everything. We also do foreign IP, which is quite rare. So we can do EU and US-based filings too, which is cool. And we also do drone services, by the way. We're the only legal advisory that does drone services. And we do full applications, licensing, everything. So if any of you are thinking about that, come speak to me. Highly regulated. Cool, guys. Thanks very much for your time. I really appreciate it.